So, mediation is an informal process where we all get to sit down and decide what happens to your future. When I say your future, this is for your divorce. If you were to go to court, walk in, and have a hearing or a trial, it's always a gamble. So, you're kind of throwing up a coin. It depends on the judge's mood that day, how they feel about moms, dads, what they just had in the case before you. But when we go to mediation, it's different. I will sit there with my client. The opposing side sits there with their attorney. We have a mediator that we typically hire. The mediator is a retired judge, or they're an attorney that practices in the area that we do in the same counties. They are very familiar with the courts. They're very familiar with the judges. They know their temperaments, and they've seen thousands of cases like yours. So they can predict pretty well what is going to happen in court, as can I and the other attorney. So what we do is we sit down and try to collaborate, try to get this done as easy as possible. Normally we have, half-day mediations or full-day mediations depending on how complicated the case is, but it is a lot more informal, easier, less stressful than it is going to court or to trial to try to divide assets, figure out what's happening with the custody for the children, visitation, child support. It's where you get to sit down and essentially agree to the terms of your divorce. There's unique cases where, especially in custody cases, where we have different work schedules where a standard possession order would not work. We have different incomes where a standard child support order would not work. And so that is a great place to sit down and figure all of this out. It's collaborative, so it's a lot easier than having a judge decide what happens to your future and your children's future. So mediation is much cheaper. And I say that because the preparation, even though we do prepare to go to mediation, we have all our documents, we have all of our exhibits, we have all of your financials. We typically try to have whatever we need that we would need for trial. The preparation is not as expensive as going to trial. Normally, if you're going to go to a custody trial or custody plus asset division, it's going to take 2 to 3 days of trial, whereas the preparation for the trial is also going to take about a day or two of my time. It's a lot more expensive. In mediation, if we have everything together and everyone's ready to go ahead and get an agreement made, you've got the half a day for the mediator, you've got half a day for your attorney, but that is essentially what the cost is. A lot of times, we might be able to get a divorce done in one mediation rather than two. So instead of going through a 8-month to a year divorce, you're really getting to mediation within 6 months and finalizing your divorce there. It's actually a little bit different now after COVID, and I say that because most mediations are done via Zoom. I typically have my client come to my office. We sit down in a conference room or in my office, where the other side is also at their attorney's office or at home. But typically the mediator does explain the goal of mediation. It is to avoid trial. We don't want to go to trial because, like I said, it's very stressful. It's hard on everyone. It is expensive. And at the end of the day, you're kind of putting your faith into one person's hand, whereas you can sit down and kind of decide what you want to do with your kids and your assets. On a normal day, a mediation will start with the mediator starting in one room. They'll go talk about what mediation is. They'll explain that it's a confidential process. The mediator will never be able to come to court and testify about what happened in mediation. We also can't talk about what happened in mediation because there's settlement negotiations, but they will go back and forth. There's a lot of downtime because we'll have a mediator sitting in the other room talking to the other side, and then they will come back with whatever the settlement offers from the other side. Normally, we have 2 to 3 settlement offers that go back and forth in a mediation to where we can have a conclusion or an agreement. So there are cases where mediation is not an option. Even with highly contested custody cases, that is a very big one, because if you have one side wanting to be the primary conservator and the other side wanting to be the primary conservator, normally there's not a middle ground. Either that, or if there is a kind of disparity where the assets are, if we can't agree to what the assets are or the valuation of the property or what the community property is versus a separate property, sometimes mediation does not work, although most often it does. So mediation is a requirement of all the courts. Here at the Bayley Law Firm, We are good at mediations. We do them very often. About 95% of our cases do settle in mediation. So if you think that's a good option for you, feel free to call us at the Bayley Law Firm and we're happy to help.